by ignoring. I'll start briefly by doing some scene setting before I hand over to our first speaker. In 2016, the government started refusing 1,700 highly skilled migrants leave to remain in the UK because of their bad character in relation to non-criminal historic tax discrepancies. This was enabled by an expansion and application of a good character immigration rule. It's a rule that otherwise relates to people considered national security threats linked to terrorism or have a travel ban. In 2019, the Home Office was found to have acted unlawfully by not allowing highly skilled migrants the opportunity to explain the discrepancies that the Home Office had used to justify refusing them indefinite leave to remain. So this is the immediate context of our session today. In my view, it's essential that we see what is happening to highly skilled migrants at the repetition, if not acceleration, of existing and deeply alarming trends. Firstly, there is the continued trend of institutionalized racism in government. The refusal of indefinite leave to remain for highly skilled migrants has been evidently racialized. As far as we know, all of those refused leave were from Black communities. All remaining cases now are from just 6 South Asian and African countries. Over half of remaining indefinite leave to remain refusals are Pakistani nationals, 70% are Muslim. A successful court challenge by the JCWI in 2020 against the Home Office also found unlawful racist visa algorithms to have been used within the Home Office. Secondly, there is a further worrying trend around a continued lack of due process and transparency. We're seeing the government developing systems behind closed doors with very few checks and balances. This issue has been brought to our attention by the excellent work of campaigners and rights organisations. And it's unfortunate that scrutiny of government is happening after the fact, after the harm is done, rather than when these systems are being developed. We mustn't forget that this infrastructure, particularly when it comes to data collection, management and processing between government departments, has potential implications for all of us. If we allow the government to treat one group of people in one way, that legitimizes and enables these same systems and processes, biases and all, to be applied to others. We're already seeing the implications of this for how highly skilled migrants are treated, but it has implications for how all migrants are treated. It has implications for what kind of profiling is deemed acceptable, and it has implications for all of our data rights and how information is shared and processed by and between government departments. So this event seeks to explore and answer where we can go from here. So without any further delay, I'll now hand over to our first speaker, and that's Catherine Thane. She's a senior advocacy officer at the Migrants' Rights Network, which is a UK-based NGO that works alongside migrants in their fight for rights and justice. And Catherine, if you can talk the opening remarks for about 4 or 5 minutes, that would be fantastic. I'll give you a hint if you need to kind of conclude sooner than you are. Thank you, Catherine.
Amazing, thank you, Clive. I'll do my best. We're really grateful at Migrants' Rights Network to be able to joining up with the APPG for race and communities today, and really grateful that you've decided to spend some time coming here and listening to these issues. We want to raise the issues experienced by this highly skilled migrant community, and we'll hear from some of them later. We think they paint a really important picture about the wider policy decisions around data sharing for immigration enforcement that's been changing over the last few years. And we also believe that this is racialized and potentially even unlawful. We're keen to build the bigger picture today and hear from a wide range of people on how the highly skilled migrants' cases fit into broader immigration data sharing policy shifts. And these cases are, as far as we understand, 1,700 people of colour who were refused indefinite leave to remain, that's ILR, for historical non-criminal tax discrepancies, as Clive has said, and these have been happening away from the public eye. So in 2014, under the coalition government, their goal to reduce the net migration numbers to around 100,000, and just as the hostile environment policies were kicking in, the Tier 1 General Highly Skilled Migrant Scheme was shut down. This was a real surprise to many because there was the understanding that this was a route to settlement in the UK and why they had chosen to come here. All those who had been accepted on this visa were required to apply for ILR, and all of those I'm working with, just for context, and we'll hear from in a bit, have postgraduate degrees, 25% have MBAs, At this point in time, everyone has been in the UK here for 10 to 17 years, and most have children born here, even if they're not allowed citizenship while their decisions are pending. By talking with each other online in around 2016, some of the highly skilled group found that the immigration rule 3225 was being used. As Clive said, it's normally for national security, terrorism, or travel ban issues, but it also has this vague clause on good character, which was being used for the first time, we think, in relation to historic tax discrepancies, many of them relating to the 2010-2011 ones. And just to note here that about 60% of self-assessment tax returns of people in the UK contain some kind of discrepancies, and around 4.27 million people have made amendments to their returns between 2008 and 2018. The reasons for the discrepancies are many, including accountant errors, family and friends help, and for many it being their first return in the UK and not being familiar with the system. So we don't disagree that if tax fraud is being intentionally committed, this should be factored into immigration decisions. But what's tragic here is that there's no evidence of investigation why the discrepancies occurred before, and whether they were deliberate or careless, before rejections were handed out. So either by the HMRC in the years since the discrepancies, or by the Home Office during refusal. There's also no evidence of a balancing exercise, taking into account all else that the person has and brings to the UK. And both of these in the 2019 Court of Appeal Balajagari case were seen as really important. They said that going forward, the Home Office must issue minded to refuse letters, but this was not retrospective, so it doesn't help everybody that we're working with, and it doesn't allow them to explain their discrepancies. For those who have received the letters, they've also been really problematic, asking questions far beyond the scope of the issue in hand. For the refusals to happen, we also know that some extensive data sharing happened between HMRC and the Home Office, as Clive has mentioned. Through Freedom of Information responses, we now know that there are some memorandums of understanding in place between the two government departments that have been set up for data sharing where an immigration offence is suspected. These discrepancies are, though, neither a criminal nor an immigration offence. And like Clive said, there seems to be no protections or due process in place for data sharing. The immigration exemption for data sharing has also just been found to be unlawful under GDPR, and we'll hear some of these aspects a bit later from other speakers. We also now know, quite sinisterly, that between 2015 and 2020, when the highly skilled migrants were being refused, around 463,000, almost 500,000, people's HMRC data was shared with UK visa and immigration. So we do believe this is now a route that's been established for immigration enforcement. There's also a real racialized element to this data sharing. All those are from 6 Commonwealth, South Asian and African countries, including Nigeria and Pakistan. We also now know that Indian nationals make up about 40% of those on the visa. So in statistical terms, it might not be super unusual that they're amongst those refused, but around a quarter of people on the scheme were from the US, Canada, Australia, New Zealand and Russia, and they do not appear to have been refused for tax discrepancies. There were as many Bangladeshis, Sri Lankans, Pakistanis and Nigerians on this scheme as some of these other nationalities, but it seems to be very concentrated in traditionally non-white countries. And as Clive said, you know, over half the cases now are from Pakistan and 70% are Muslim. So we're really grateful as well, just to kind of wrap up, that some of these issues have made it to Newsnight on the 1st of June. I will happily post the link in the chat box alongside my email. A couple of things to mention. Responses from the government in that clip and elsewhere has been at the moment that everyone refused is cheating. No one is destitute, and we'll hear a bit later that this really isn't the case. We know that everybody's in significant debt from fighting their cases, and there are families living in one room or on sofas with their children. Any link to the racial aspects of this issue and links to Windrush cases that we've raised, the government says is inflammatory. When we were also looking for reference to the 3225 clause online on the immigration rules, we found that that section has now been redacted and is covered with a disclaimer that these clauses are for Home Office internal use only. And that's changed in the past few weeks when this has been coming to light and on Newsnight, for example. One of those who's also spoken in the Newsnight piece has also a few days after speaking on Newsnight, has also had his case rejected, even though he's been waiting for months. So we're worried that there's a culture of silencing going on for those who are speaking out. We're keen to pursue a number of changes, including around reinstating right of work for all of those refused. About over half of people still don't have a right to work. We want to ensure as well that this situation never happens to anybody else going forward, including those under the new highly skilled scheme just announced. So we want to ensure that non-criminal actions are not a grounds for ILR refusal, and that data sharing is lawful and has due process and protections in place. We also really want to ensure that those who have been disproportionately punished for something many in the UK have done are given indefinite leave to remain, and perhaps provided reparations even for the 1,000+ cases who have now later been found to be telling the truth. So all of this leaves many questions for attracting global talent that the UK needs. If this is the precedent, that your discrepancy is as low as £1.30 in one case, you can be punished for that. And after many years of living and working here, it can be decided whether you are good or bad for the country, seemingly based on assumptions without any investigation. Without citizenship, you're held to almost impossible higher standard than the rest of those of us in the UK, and not treated with dignity when you're assumed to be cheating the system. So I don't believe this is an attractive environment for anybody to come and work in the UK and set up a business, and would love anybody's help here in raising these issues here today, and would be really delighted to follow up as well. And handing back over to Clive. Thank you.
Thank you, Catherine, and thank you for that overview of the issue, which I think sets us up nicely for our next speaker, who I will come on to very shortly. Just a little bit of housekeeping before we go on. You will see on the tabs below, I'm sure you're all aware of this. If you've got comments to make as we're speaking, not necessarily questions, then please put them in the comments box, as you know, the chat box. And if you have a question for the panelists, which we all have a Q&A at the end, then put them in the Q&A box, and then we can make sure that that gets asked at the end of the speaker's session when we have the question and answer. And if the panelists, whilst others are speaking, can look at the questions, if there's any there that you particularly want to take on, then contact me or by the chat box, or answer it yourself in the Q&A panel. So our next speaker is Baroness Mubarak. She's a Conservative Party peer who was formerly a Conservative Party member of the European Parliament and a former chair of CBI Scotland. Baroness Mubarak, over to you. Thank you very much for coming.
Thank you very much. Very pleased to be able to join you today. The subject of highly skilled Commonwealth migrants was discussed during oral questions in the House of Lords on April of this year. And in all honesty, it was at that point that I really started to pay some attention to it. I mean, I felt that there was just too much of a disparity between what the Migrant Rights Network's analysis of the situation and the government's analysis in response to it. So I have since been briefed by Catherine, and have, like the rest of you, I'm sure, watched the piece on Newsnight, which illustrated the dire situation that some people find themselves in, having come to our country in good faith and to build a future for themselves and to contribute to the UK. So I am due to meet with a senior member of the Home Office to discuss this subject, and I'm grateful, very grateful to have that meeting. It's an informal setting, and I'm looking forward to a positive kind of discussion around this. But as you mentioned, CBI Scotland, I mean, having headed up Confederation of British Industry in Scotland, I'm well aware of the importance of all migrants to the UK. Those in so-called low-skilled roles, just as necessary, as well as those who are highly skilled, all critical for building prosperity in the UK. I recall some of our members who were owners of care homes or in the hospitality industry, whose businesses were completely dependent on migrant labour, both skilled and unskilled. And it was a subject that was discussed often. And I worked hard during my time at CBI Scotland to lobby and make it a policy of the Scottish government. At that time, it was a Labour government in Scotland, to allow a 2-year working visa to foreign students. It was a way for these young people to get proper work experience once their studies ended, and in turn it was a way for Scottish businesses to benefit too. But the highly skilled migrants on the 2008-2014 Tier 1 general visa came from around the world, many studying postgraduate degrees here to set up businesses and create jobs that did not already exist. And they could have done it anywhere, but they chose the UK. It's people who are entrepreneurial, ambitious, motivated, who take up such opportunities, exactly the kind of people that we want and we need. In fact, you know, and the statistics have been mentioned earlier, but perhaps, you know, always worth mentioning again, show that 90% of these highly skilled migrants have postgraduate degrees and 25% have MBAs, and another indication of the kind of hard-working people that they are. They understood that the Tier 1 visa was a route to settlement in the UK after 5 years, if they continue to run their businesses or have employment. But after 6 to 8 years on the visa, the terms have suddenly changed and everyone was required to apply for indefinite leave in an environment in which the government was already seeking to reduce net numbers of migrants to 100,000. I'm really sorry to have to say this, but the demographics of the 1,700 people refused leave to stay also tell us an important story. The information that I have indicates that every one of those is non-white, despite the variety of nationalities on the visa. The majority of cases MRN is in touch with are Pakistani nationals, even though they were not the most numerous on the visa. The number of Bangladeshis and Sri Lankans is also very high for the relatively low numbers on the visa. And as Catherine said, 70% of those that she's in touch with are also Muslim. Now, the Conservatives' inquiry into Islamophobia acknowledges that there is anti-Muslim sentiment in the party, my party, which is really regrettable. But I know that the majority of my colleagues would not fit into that kind of category of being anti-Muslim. But this is something that needs to be acknowledged, the fact that it is there, and for us to have some kind of reform so that we can safeguard against conscious or unconscious biases impacting decision-making and policy. Islamophobia is very real and distressing for those who are at the receiving end. And if we want, as we say, to be a truly inclusive society, then we have to face up to its existence and to make efforts to address it. Unfortunately, the highly skilled visa holders, particularly those from South Asia and Africa, have faced many more barriers to the job market and even in renting accommodation when they were on that Tier 1 visa, much more so than the US citizens, Australians and Canadians on the same visa scheme. Now, it's important that we work on any culture of mistrust that has built up with our civil servants so that decisions are genuinely fair and equal. And it's also important that we build environments in the UK which continue to attract the global talent we need for the UK economy post-Brexit in order to function well. And this includes building support within the business sector. Post-Brexit, we must build closer ties with Commonwealth countries. What we don't want to do is to invite or encourage people from the Commonwealth to come here and then treat them badly. It is devastating for the individuals concerned, and it is not in our interest either, for it certainly doesn't reflect well on us. What we want is to be a fair, outward-looking, truly global Britain, unhindered by either conscious or unconscious bias. I am hopeful, though, that the government will be open to listening and to taking on board the considerable amount of statistical evidence produced by the Migrant Rights Network so that any wrongs or unfair treatment of people can be put to right.
Baroness Mubarak, thank you very much for your comments. And I think you're reiterating the fact that there is cross-party consensus on this issue. And I thank you very much for speaking today on that in a very powerful way. And keeping to the cross-party consensus theme, I'm happy to introduce our next speaker, Anne McLaughlin, MP. She's the SNP MP for Glasgow North East and the Shadow SNP spokesperson for Immigration, Asylum and Border Control. If you'd like to share your thoughts with us now for the next 5 minutes. Thank you, Anne.
Thank you very much, Clive. Imagine a situation where you have a minor tax discrepancy hanging over your head. For most of us, that just means reminding ourselves to amend our tax return or call the accountant to sort the problem out for us. The worst that can happen is a small admin fee or a fine from HMRC. But as we've heard, for a number of highly skilled migrants who were invited to these islands in a series of UK government initiatives, a minor discrepancy in their self-assessment tax return, which is not difficult, I've done them, it's not difficult to get it wrong, resulted in them being stripped, as we've heard, of their right to work, rent, drive a car, open a bank account, receive healthcare, and ultimately their right to live here. Using a provision of the immigration rules intended to tackle criminality and national security threats, the Home Office, along with HMRC, have racially profiled and targeted a small minority of migrants and unfairly held them to a much higher threshold than the rest of us. And I agree with Clive that this frankly scandalous situation is but one amongst a host of increasingly regular moves by the Home Office to discriminate against minority groups. As the SNP spokesperson for Justice and Immigration, I'm horrified at measures which have seen some migrants detained in immoral and traumatising dawn raids, others denied access to the money they're entitled to feed their children because of mismanagement of a payment card system, and yet more migrants being housed in army barracks unfit for human habitation. And right now as we speak, that's exactly what's being debated in the House of Commons. Despite the questions, letters, debates, widespread media coverage, and the cross-party consensus we're seeing here, all backed by credible evidence, the Home Office persistently deny and dismiss any allegation of wrongdoing ever. This is the front face of the hostile environment, and for what? They'll say it's to tackle undocumented migration, but whether or not you agree with their methods, there's simply no evidence that it works anyway. In a number of these tax discrepancy cases, Home Office decisions have been overturned, with judges describing the sanctions as entirely disproportionate. Some of the sums involved are as low as £1.20. These are clearly honest mistakes, and as far as HMRC are concerned, when the correction's made, the case is closed. But that's as it should be, and that's as it would be for those of us born here, but not as far as the Home Office is concerned. Paul Garlick QC, who specialises in extradition and human rights law, said the following in regard to the Home Office investigations. He said, "My feeling is that since Theresa May's announcement of a hostile environment for immigrants, caseworkers have been told to look for discrepancies that could form the basis of an accusation that the applicant is lying, because that's the quickest way to dispose of an application." That's some accusation and not one that a QC would make lightly. Highly skilled migrants, by their very definition, are highly talented individuals, once welcome because they were needed here, who are now left in limbo. And what's most worrying is this fact that, as we've heard, that all the remaining refusals are migrants of colour, all from 6 South Asian and African countries. Over half are Pakistani nationals, 70% are Muslim. As someone who has campaigned for most of my life against racism, this profiling and targeting of ethnic minorities by the state chills me to the bone. And as I said earlier, it's all part of a wider, disturbing and fast-moving agenda. We only have to look at the policing bill that's going through Parliament at the moment to see another set of people consigned to lose their homes too for also a relatively minor offence, and that's gypsy travellers, who, if they return to a site that they've been asked to leave within a certain period of time, can be jailed and their vehicles can be confiscated. But if you're a traveller, often your vehicle is your home and your child's home. How has it come to this? How has the UK become the kind of place where a minor infringement of regulations, whether it's gypsy travellers needing to stop for a night or highly skilled migrants making a simple miscalculation, leads to you losing your home and your children's home? I find it deeply frustrating anyway, but more so being a Scottish MP, because in Scotland we have a government that's opposed to all of this, that has well thought through immigration policies based on respect and openness, and yet we are powerless to implement them. And whether you support it or not, and I respect everyone's point of view on this, I hope it's useful to know that independence for Scotland, it's not a vague notion. There are reasons why someone like me has been campaigning for 33 years for it, and that's just one of many. But right now, the task in front of us all is to change the UK immigration policy. And I'll end by saying this: whether it's about asylum seekers seeking safety, highly skilled migrants helping to grow our economy, or, as is often the case, as Baroness Mubarak mentioned, migrants willing to do the so-called unskilled or so-called low-skilled jobs that employers find difficult to fill otherwise, the UK's immigration policy must remove hostility and must replace it with fairness, humanity, dignity and respect, because that's exactly what we expect when we venture out to other countries.
And thank you very much for that impassioned plea. I'm also aware that Glasgow has made its views on hostile environment known in a rather public and high-profile way. That's something I think many of us would have cheered. Our next guest is Salman Farrukhi, and a member of the highly skilled group affected by this issue. Thank you so much, Salman, for joining us. Really important that we hear the voice of those affected by this policy. So please begin your talk now. Thank you very much.
Thank you very much, and thank you all the honourable member of the Parliament and everyone who has joined in support of Tier 1 General Migrants. And I thank you to all of you basically on the behalf of Tier 1 community. My name is Salman Farrukhi, and I'm representing the HSIN Group as one of the organizer, basically the people who started this group in 2016, 2017. When we all were getting refused one by one, and we didn't know the reason, basically, what is this 322.5, seeing the threat to national security as being a Muslim, as being a Pakistani, and seeing on my refusal letter 322.5, threat to national security related to terrorism, anti-war crimes, and these kind of things. So, I mean, that was quite shocking for us to see. So we contacted the other people of this category through different social media channels, through immigration groups, Facebook, Twitter, and added all those members in Telegram groups and on WhatsApp group. And very soon we became like about more than 500 members in the group. And then we all discussed, we all were highly skilled basically. Everyone had their own thoughts and ideas that how to move the campaign forward. So we were meeting different law firms, and luckily we met Migrant Rights Network in 2017 and got tremendous help and continuous support we have been getting from Migrant Rights Network and from Fiza and now from Catherine. I mean, we don't have words to say thank you to these people, basically what they have done for us. We raised our voice on every forum. A lot of articles and stories in the newspaper came in our favor. There were some documentaries on the TV as well. We also held 6 protests outside Downing Street and Parliament, and we got a support of over 40 MPs cross-party. And we are really thankful for Afzal Khan MP, Alison Tullis, Jess Phillips, Faisal Rashid, Ruth Cadbury, I mean, and many other MPs basically from different parties who have supported us. There was the debate in the Parliament as well. From Alison Tullis, where the questions were asked from the Home Minister, but the answers we got basically just they relied on the review that was coming forward. And at this moment of time, over 70% appeals have been allowed in our favor, and all those members are settled in the UK, including myself. Like I got the passport 2 years ago. I was settled. The judge clearly said that there was no dishonesty at all. In my case, and not only in my case, in over all those 65% of appeals, basically the judge said that they don't see any kind of dishonesty. There may be some careless behavior, that this was the first tax attempt from the applicants, and there were some mistakes basically that can happen from any person as well, regardless of any nationality. You know, that's the human error, mostly from the accountants or from the applicants themselves. Home Office, in their own review, they accepted that they have lost over 65% of appeals and there were flaws in their system. Same in the Balajigiri judgment. that with the help of Migrant Rights Network, we intervened in the case in Court of Appeal, and we won that case, and Home Office accepted that there were many flaws in the system. Even the judges criticized them a lot. So the only few members that are left at the moment basically are ones whose case was not represented in the courts correctly, properly by their solicitors or law firms, or they did not have much evidences to support their cases due to the duration of the mistake that was 7 to 8 years ago, you know. But this does not mean at all that the Home Office has got any evidence against them to prove them dishonest. So in these kind of cases, benefit of doubt should be given to the applicants basically, but this is not happening. Home Office is not even using their discretionary power to give them the visa. I will quickly give you one example of one of our members. His name is Imran Mubarak, and with his consent, I am giving the example basically. Imran came into this country in September 2005 as a student. In November 2011, he was granted Tier 1 General Visa up till 2013. In November 2013, when he applied for visa extension of his Tier 1 General, he was interviewed by the Home Office, and Home Office refused him on 19I-19J for two reasons. There was no 322.5 initially on his refusal, but in the interview, that Home Office thinks that he underperformed in the interview, and Home Office is not satisfied that his business was genuine. The second mistake they pointed out is that he provided the bank statement for the maintenance when we had to show £800 for up to last 3 months. By mistake, he sent the bank statement, only 1 month old bank statement, not within 30 days, which Home Office could easily ask him to send the updated bank statement, but they preferred to refuse him. Now he underperformed in the interview because he had a very important, his wife's surgery, very severe surgery, basically during the time he was giving the interview in the Home Office. I mean, maybe this was the reason he was panicking. But what was the qualification of the caseworker of that to find out that his business was ingenuine? I don't know what was the qualification, what was the caseworker's experience to find out that the business was not genuine. He has got all the documents about his business, all the proofs, his genuine bank statement for not only 3 months, for the whole year that the maintenance were there in the bank statement. He got the right of appeal, but his case was completely messed up by his then solicitor in the appeal. And then he could not get the permission as well from the UTT, you know, because the solicitor, he did not represent the case. He did not point out all the evidence properly. So of course, the judge did not give the permission as well. Then he met another solicitor from Franjaved Taylor. His name was Christopher Chang, and he wasted like about 15,000 in applying different applications. The solicitor misguided him to apply for different human rights applications that were not even relevant to his profile, you know, and he keep applying for different applications. And what happened in the end, that this solicitor, Christopher Chang, he was found guilty from the court that he was taking money from the applicants in the name of Home Office application fees, and he was depositing all that money in his own account. There is a court judgment against that solicitor. There are several media articles against that solicitor. And Imran later on found out that there was no application in Home Office at all, and he was overstayed in this country. Since then, he doesn't have right to work for the last 4 years. He doesn't have a single penny, because when he contacts to the solicitor, of course, they ask for the money to represent his case. And how does he represent the case? But if he is surviving to eat the food and to give the rent, basically by taking money from the friends and family. And he is only hoping at the moment that one day he will get some kind of justice through the HSIN Group and through Migrant Rights Network and through the people like you. Imran had no tax discrepancy at all. He had paid the complete tax in time for all his applications. And later on in 2017, in the next refusal, Home Office put 322.5 as well. So same thing, that being a Muslim, Pakistani national, 322.5 with wordings threat to national security. And with no tax discrepancy at all, no financial allegation or anything. It is just that the Home Office thinks that your business was not genuine. So this is how the people are surviving in our group, basically, that if someone's accountant has done the mistake and the accountant is not contacted anymore because the accountant did the mistake in 2010-11, and now in 2021, how if they are not in the contact with the accountant, how do they find the accountant? Or if they don't have any documentary evidence of such, an old tax amendment. So, I mean, this is some real injustice happening with our members. And I mean, we are committed to, we are just like a family, you know, so we will be together up till the end until each and everyone is sorted out in our group. And we are hoping to get the justice, and we just implore all of you for the help as well, please. Thank you.
Salman, thank you very much. It's very important to hear your voice, and I thank you so much for speaking up today and speaking out. It's really appreciated and really important. We are a little bit over. I've been overly generous with time. So obviously the downside of speaking at the end is also that you have to share a small amount of time. So I'm going to be very strict on timings now. Our next speaker, gives me great pleasure, is Patrick Vernon, a social commentator, a campaigner, and a cultural historian. Patrick, the floor is yours for the next 5 minutes.
Okay, thanks, Clive. I'll try and stick to time. It's really great to be here with parliamentarians supporting the cause, Migrant Rights Network, and running for so many organisations. I've been campaigning, as you know, around the whole issue around the Windrush scandal, particularly people that came from the Caribbean, but also people from Africa as well. And there are lots of similarities, but differences in terms of the issue. The commonality is a Home Office, the hostile environment policy, and also that we have to look, if we look at the history of Britain, particularly post-war Britain, the success of Britain has been built on migrant labour from all different parts of the world, particularly from the Commonwealth. And that's really important. And when Wendy Williams did her review on the Windrush scandal, called the Lesson Learnt Review, one of her recommendations was that Home Office officials, and even politicians, did not understand the history of migration, did not appreciate the history of the migrant contribution and the rise of multicultural Britain, multisecular Britain. But what had happened, especially from the time of Enoch Powell's speech in 1968, Rivers of Blood, there's been a toxicity around the issue of immigration and migration, despite the fact of the 1948 British Nationality Act, which gave the right for everyone that were in the colonies and the former to come here to Britain. There's been successive immigration policy to classify black and brown people as second or even third class citizens. And that is the situation that we're at today in terms of how the women's generation were treated, how asylum seekers and refugees are treated now, and particularly this debate that we're having around skilled migrant workers. The women's generation were skilled migrant workers. They came here in the 40s, 50s, 60s, and 70s. But when we had the Immigration Act of 1971, they were declassified, not being recognised as skilled migrant labourers. And when the government introduced their legislation to encourage more skilled migrant labourers, and then declassified that because of the hostile environment policy, everyone is in the same boat. Black and brown people, where we've come from, different parts of the Commonwealth, with the nature of the Home Office, as Clive said at the very beginning, is structural racism at the heart of this. This is really, really important, and that's the commonality that we have to work towards. And what's interesting, when it comes to immigration and nationality, and if you look at all the opinion polls over the last 20, 30 years, people want to have tough immigration control. And even people from within the black and minority communities talk about that too. But what's interesting is when we had the Windrush scandal in 2018, it had support from the public. Millions of people around Britain were appalled to find out that the government were basically deporting people losing their livelihoods because of hostile environment policy. There was cross-party support from UKIP to the Greens. Everyone, even Nigel Farage was supporting the Windrush generation for a while. Anyway, that's not a story. But what was quite clear that there was cross-party support because everyone recognised that the Windrush generation were British, they were skilled migrant workers, and they have contributed to Britain over and above. And this is no different to the skilled migrant workers that we're talking about today. They have contributed to Britain, they've made a difference, they were invited slightly differently, but they still should be recognised for their contribution. But as we know, at the heart of this is hostile environment policy. This has to be got rid of. This was a recommendation that was made by Wendy Williams and Lesson Learned Review, that there have to be a review. The Home Office and Priti Patel have not taken this seriously at all. And what the government are now doing are ramping up the hostile environment policy. And the hostile environment policy is based on the premise of fear and intimidation. So the fear is that we're going to deport you. We're going to stick you in a detention centre. And the intimidation is, if you haven't got your paperwork, which irrespective of it's from HMRC, from the Home Office itself, or elsewhere, we deem you as an illegal immigrant. And this is quite important. We need to get rid of the hostile environment policy because it's destroying lives. 21 people have died in Britain without receiving a single claim of compensation from the Windrush Compensation Scheme. But many others in the Caribbean, Africa, and other Commonwealth countries are also suffering the same fate as well. And despite the fact that since 2018, there have been over 10 reports, 2 reports from the Home Affairs Select Committee, 2 reports from the Public Accounts Committee, and 2 reports from the National Audit Office, as well as Wendy Williams' lesson reports. All the reports have been critical of government policy, have been critical of the operation of the Home Office, but yet it falls on deaf ears. I hope that we work together in terms of the leadership under Clive and the all-party group and all the organisations, campaign organisations, to make the case. Because I think this is a public health issue. People don't look at this. If over 21 people have died, you've got tens of thousands of people, and that includes now the skilled migrant networks, all suffering from post-traumatic stress disorder because of the way that they've been treated and put through the mill by the Home Office. This is a public health issue. It's no longer an issue of immigration, nationality, or border control. It's a public health issue. And we need to put the same level of resources, same level of intent as we're trying to tackle the whole issue and situation with the vaccine and COVID-19. I've spent so much time with the Windrushers, and they are so traumatised. And yet the government talks about the right and the wrongs. Anthony Bryant, whose life story is based on the successful BAFTA award-winning drama, Living Sit in Limbo, was interviewed only this week. I spoke to him a few days ago. He received a compensation offer from the Home Office, which does not reflect his life, that he needs to move on. After having 2 spells of detention, he suffers from a whole range of physical health problems and mental health problems, and yet the compensation scheme is a joke. We need to make sure that we change this. But in the context of this debate around skilled migrant network workers, those skilled workers are in the same poverty situation as those Windrush generation that were first had the experience of the hostile environment policy. We need to have a policy of humanitarian support. The Home Office needs to be broken down. It's just too unwieldy. And we need to get rid of the hostile environment policy. And we want the Home Secretary to actually engage with the skilled migrant networks and listen to them. No, her parents were skilled migrant workers themselves, but that seemed to fall on deaf ears. Instead of spending more time going around different parts of the Commonwealth to have tighter security controls or to go with border enforcement people, where is the humanity? Where is the empathy? Where is the respect? All migrants have contributed to Britain to make Britain great, but yet we still have structural racism which ignores and gaslights all of us. Let's work together to make sure that skilled migrant network workers are valued and respected, and to change the rules and regulations so they can contribute. If the Foreign Secretary can automatically give 3 million Hong Kong Chinese people automatic status of coming to Britain, why can't we deal with the same situation here in the UK? There's something fundamentally flawed that we are degrading.
Patrick, I'm going to have to close you down now, unfortunately, my friend, if that's okay. But thank you very much for your contribution. It's really appreciated. There is another speaker that I wasn't aware of that does need to speak, and I'm going to bring him in next if I can. And I do apologise because he's not on my list, but his name is Abiome, and he's also from the highly skilled community that has been affected by this policy. He won't be turning his camera on for, I imagine, obvious reasons to most of the people here today. Abiome, the floor is yours for the next 3 or 4 minutes. If you could keep your words tight, I'd be really appreciative.
Thank you, Clive. I appreciate everyone for coming. Thank you for for your time. I appreciate the MPs and the Baroness and Catherine. As Salman said, we can't thank you enough. We've been very good to us. I'll be very brief with my story. I came to the UK almost 12 years now. I've been here for almost 12 years now. And for my master's, which I successfully completed, and then had my right to work taken from me after I applied for my indefinite to remain in 2017 as a migrant worker because of one amendment which was done. I did a task myself because my accountant was not around, and I informed him that, okay, this is what I've done. He said, no worries, you have 5 years to amend anything in the UK lawfully, there's no problem. So, and then I left that for him to do that. In the process, because I lost my mother-in-law in the 2017, I went for premium at Cardiff to get like 1 day or 2 days decision visa to I can go and then for a funeral. But I mean, I couldn't. They didn't answer me until after 6 months. They declined it. I couldn't go for the funeral. In that process, I lost my mom also 2019. I mean, it was really tough, and I lost my right to work for over close to 2 years. I was over 13 months in rent, which was almost, destitute, with 2 children and my wife. So it was really tough to the extent that I have to freeze all my credit card. I couldn't really pay any one of them. I sold my car because I couldn't pay for insurance and then maintain it. So it was really a tough time during that time. When the Balajari case come up, I got my right to work back, and the Home Office wrote to me, apologized to say they will pay for my legal fee from the judicial review to the Court of Appeal, that they will pay for it. This is over 2 years, about 2 years now. I've not heard from them. My barrister said he has sent them the invoice, but nothing from there. So there's after about in July 2019 or so, around July, August, they sent me a mandate to refuse letter for over 100 questions, asking me something that has happened for over 10 years to be bringing, evidence of so many. I just wrote to them as all these things. I can't really, anyway, with the input of my barrister, I sent over the questions and then answered the questions and every evidence that's available, but they still declined it and said, no, they are not satisfied. And then at the end of the day, they just push it to the FTT. So we are the FTT now, they're waiting for, but the FTT gave the Home Office till next month, till August, first week in August, to review their decision, or else we'll go in for full hearing. So this is where we are at the moment. So I'm really appreciative you guys can really step in to support the highly skilled migrant. We came around here. It's a home for us now. I mean, there's no place we want to go again. I have my wife, two of my children are here with me. One of them is going to uni in September. At the moment, he cannot apply for a student loan, because if it's by September is going, if he can't apply for student, they will ask me to pay for foreign students, which is so high. I don't have that kind of money to pay for such now. So, but if my settlement is settled, definitely will be able to apply for student loan and all that. So I really need your help. Thank you very much.
Thank you very much, Abiome. And again, thank you for your contribution. It's really important to hear your voice, and very brave for speaking today, so thank you. Can I introduce our next speaker? We have less than 10 minutes for the next 2 speakers, so if you could keep your remarks brief, and then I'll make sure that you get your fair share of questions as well. But our next speaker is Rosa Curling, Director of Foxglove, who are a team of lawyers that I have worked with personally myself. They're technology experts and communication specialists, which exist to fix the misuse of digital technology by governments and big tech. And unsurprisingly, they're very busy at the moment. Rosa, over to you.
Thank you so much, Clive, and thank you so much for the invitation to address everybody here. As Clive says, Foxglove is a non-profit company, and we basically exist to try and make technology fair. And I've been asked to speak about a case that we took against the Home Office, which was to do with the Equality Act and to do with an algorithm. I'm a public lawyer, so I take judicial review claims, and one of the focuses of my work at the moment, and of Foxglove's work, is to ensure that the public law principles and obligations which apply to human decision making also apply to data-driven decision making. So the case that we took with JCWI was a challenge against the Home Office under the Equality Act, and it challenged an algorithm that had been in place for many years in complete secret, and no one was aware of it. We became aware of it only because of an article that featured in the Financial Times, which revealed its existence. Having discovered its existence, we then started to ask a whole series of questions, including requesting a copy of the algorithm and also some details about the data that was in fact being put into the algorithm. And we were really alarmed by the information that was provided to us. The purpose of the algorithm was to rank applicants. So the individual applicants were literally assessed and allocated a rate risk of red, amber, or green. If the application was rated red, then his, her, or their application was scrutinised in a very different way to if you were rated green. And if you were rated red, the chances of you getting the visa was greatly reduced. What became clear through the disclosure that we obtained was that nationality was one of the criteria being used to determine the risk rate. In other words, if you're applying with one nationality, then your application is going to be treated completely differently from someone else who's applied with another nationality. That is clearly contrary to the Equality Act, and we challenged it in the High Court in London. This situation was made worse by a negative feedback loop, which basically meant that this list of risky nations that the Home Office kind of created, and it was never disclosed to us, but if you were somebody who was from one of those nations on that list, and that list was in essence created by negative refusals of visa applications, you were basically, with a negative feedback loop. So the chances of your nation ever coming off that list was basically impossible. As I said, we challenged it in the court, and I'm pleased to say that the Home Office conceded the claim. They conceded that the algorithm had to be withdrawn, and it was withdrawn immediately. And although there is no judgment because of the concession, what this case shows is that the Equality Act and all of those principles of non-discrimination and equality apply in relation to the Home Office when they're making decisions by data-driven decision-making, or for example, like we have in the case here with the highly skilled migrants, when you're looking at data sharing. So Foxglove is now with MRN turning its attention to the question of highly skilled migrants and looking at the data sharing agreements that have been put in place between the Home Office and HMRC. And we're starting to ask the similar sorts of questions that we asked in relation to the algorithm. And we want to start investigating the lawfulness of the basis in particular upon which the Home Office has created the list of individuals from whom they seek information from the HMRC. And we've asked to know on what basis those lists have been created, and also asked for their equality analysis, which had to be completed prior to any data sharing taking place. And I'm sure kind of we or Catherine will keep everybody updated on whether there is a legal case and how that looks moving forward. Thank you very much.
So much, and for being really short, sharp and punctual on that, and informative. Really appreciate that, Rosa. Our final guest is Sadia Dar. She's an immigration policy manager at the Open Rights Group, which is a UK-based digital campaigning organisation working to protect our rights, privacy and free speech online. Over to you, Sadia, and we will be finishing at 12 if that's okay. Thank you very much.
So I was asked by Migrants' Rights Network to speak about the wider context of government data sharing. I'm watching the time, so hopefully I'll be exactly 4 minutes, just like Rosa. So basically, it's difficult not to consider what has been said before me in the context of the government's stated desire to increase the collection and sharing of personal data and what this means for privacy, civil rights and civil liberties. We've already seen the government pursue data sharing practices for immigration enforcement. and this has intensified during the pandemic. The UK government has been described as wanting pandemic levels of data sharing to be the new normal. Nowhere was the desire for increased data sharing more evident than in the government's national data strategy, which was launched last year. The government has been extremely keen to explain what benefits will be reaped by businesses, government, and organizations by accelerating data sharing. However, it has been less keen to address the risks that this poses and detail what safeguards it would put in place to mitigate against these risks. So at Open Rights Group, we're currently working on Migrants rights groups to challenge the Cabinet Office's National Fraud Initiative data matching powers proposals, and recently responded to the National Fraud Initiative data matching powers consultation, where we raised general concerns, but also specific concerns relating to migrants, as we suspect that data matching for immigration purposes is on the cards. These proposals would dramatically expand data sharing powers in the public sector. And what not so many people know or realize is that, similar to the Police Crime Sentencing and Courts Bill 2021, the police would be given more power. Expanding the NFI regime will mean a lot more data being shared about migrants and new opportunities for abusive behavior from authorities. And of particular concern is the extension of data matching powers to allow police to use the service for the detection and prevention of any crime without any restraints on what information they can request to ensure that this is necessary and proportionate, such as independent authorization. And the potential for inappropriate usage, targeting of individuals or groups is vastly expanded. This is exacerbated by the lack of external oversight for requests. Police are granted, in effect, a blanket power to gain any information currently collected for fraud investigations without needing to gain permission. These new mandatory powers for dealing with errors are a huge expansion of state data sharing that requires a much more broader debate. This is a form of automated profiling, which is recognized in data protection law to carry higher risks. And while fixing errors may seem a good reason for sharing data, this can have negative consequences, as we've seen, and can be perceived as intrusive, even when it is delivering benefits to those who are entitled. There are problems with stigmatization. And I'm just going to end now by saying that Orgwa's Open Rights Group, where I work, was part of a policy process to increase data sharing in the Digital Economy Act 2016. And these concerns came up repeatedly. And our basic principles at the time, and still stand today, were that org's minimal criteria that data sharing agreements should not lead to a widespread intrusion on people's privacy. They should be proportionate, limited in scope, and enshrine fundamental rights, and carry strong safeguards against willful abuse and unintended consequences.
Sadia, thank you so much for that, and thank you for being on time as well. I'm going to come back to you with the first question because you were so punctual, if that's okay.
I feel like I just need to breathe.
Of course. The first thing to say is that our speaker, Anne McLaughlin, had to leave at 12. And I know she has been answering questions on the Q&A session, and she's also requested if anyone does have any questions they'd like to ask her as the SNP spokesman on these issues. And if you make me aware or Runnymede aware, we will pass them on to her with your contact details and she will get back to you. So I guess my first question is to Sadia, Catherine and Rosa. Is there a broader issue to be discussed in relation to the racial profiling and data sharing outside of the Home Office? So if you'd like to very quickly answer that, Sadia, and then maybe Rosa and Catherine would come in on that as well.
So I would say yes, and we did raise this in our submission to the NFI National Fraud Initiative Data Matching Powers consultation. And we've not only seen this with the consultation proposals, that there's a risk of, when you're dealing with vast amount of data, that there is likely to be the risk of profiling, but also in other issues that have been raised with us with migrants' rights, with us by migrants' rights groups, such as fingerprint scanning, biometrics, and the case of highly skilled migrants.
Thank you. And Rosa, what's your take on that in the wider picture?
I think yes, sadly, definitely. There is a real inherent risk, for example, in relation to almost all algorithms, that there is inherent bias within them all. I also think that it's not any surprise that, as as we've heard from our previous speaker, that in reality the most vulnerable communities in our societies are the ones that are being hit worse by these kind of data sharing agreements, the data driven decision making, because there's a way in which I think sadly we often see the state trying to get away with things, trying new kind of equipment, new technologies on the communities they think won't kind of shout out and challenge it, which is why I think it's so important and so brilliant to see so many people here trying to think through what we can do to assist with this particular community.
Thank you. Catherine, did you have any input onto that?
Nothing immediately particularly to add, but just that we are aware of this. There is something to add. We are aware of this happening with other governments. There are memorandums of understanding for data sharing between different government departments, and that includes with the NHS as well. So I know Foxglove are working on a campaign that's also looking at kind of private sector involvement in contracts. But we know, for example, the NHS and Department of Health and the Home Office data agreement has been suspended because it was found to be unlawful in 2018. So this seems to be another one that's set up between two other government departments that has affected 1,700 people. And yet we're only kind of learning the full extent of what's happened years down the line now, and nothing has changed. There's no policy that kind of prevents this from happening or allows people to have any justice for what's happened to them.
Thank you, Catherine. I was going to direct the next question at Patrick and Baroness Mubarak, but she's actually left, and she thanked everyone before she left. You'll see that in the chat. But I am going to ask this question of you, Patrick, and anyone else that wants to come in, because I think it's a very important question. And it's from Nira Sigaran. And the question is, why is this action is clearly detrimental to the Home Office's drive against portraying themselves as fair and transparent? How have they managed to be so blatant in their actions and with such scandalous decisions? The worrying situation is that they continue to do so with their complete disregard for our plight, even after the issue has been raised so openly. So Anne McLaughlin has answered that. I guess what she's saying is, what's the bigger picture here? Why are they doing this? Don't they care about what the public think about them, especially given what you said, Patrick, as regards to Windrush? Is there a deeper story here that we're seeing, or is this just a mistake they've made and they'll rectify it? What do you think?
I would love to think that it was a mistake they made and they would rectify that, but the Home Office sadly has got form on this. As you know, but the problem that we have is Brexit. People voted for Brexit because they wanted to have tougher immigration control. And the Home Secretary has made it over and above in her role by going on border controls, enforcement controls, to demonstrate that the government is tough on immigration. That is a context. So how do we change and influence public opinion so politicians across all political parties look at the human suffering and the impact of the physical and emotional well-being of racist immigration policy? That's the real issue here. The reason why a lot of people supported Windrush, got behind Windrush, is if you look at the Black community and the migration of Black people, particularly African Caribbean people, we're probably more integrated in British society than other migrant communities. And we have this shared history of around empire and colonization and enslavement. And also in terms of the whole interaction of people, we're everywhere in Britain in the sense of recognised visibility. So when people found out that their partners, friends, neighbours, work colleagues were potentially threatened with deportation, people could identify with that. But we need to get people to identify with skilled migrant workers. They also have contributed. We have to recognise, what about refugee and asylum seekers, basically? I used to be a civil servant in the Department of Health, and there was a pecking order, as politicians all know this, that at the top is a Treasury and at the bottom is a Home Office, because the Home Office is doing the dirty work and historically has done the dirty work of introducing, implementing unfair unsavoury policies. So until we have a different type of approach by government and politicians, the legacy of Enoch Powell speaks Rivers of Blood still permeates even today in all political parties. And we need to change that mindset to talk about immigration in an engaging way, in a more progressive way. And this is really important. We have to change society. We have to change the perception of immigration, that immigration and migration is good for Britain, not bad for Britain or indifferent to Britain.
Thank you, Patrick. Salman, I saw you nodding there. Would you like to come in, or Abiome, either of you or both of you? Would you have a view on that? What does your gut instinct tell you about the motivation behind this, as people who are experiencing this directly?
Basically, I mean, the motivation, I would say, for the Home Office, do you mean, right?
Yes, and the government.
Because what we see post-Brexit, basically, that the Home Office, they wanted to reduce the number of immigrants, but mainly the people voted in the Brexit, basically due to the other reason, not only to kick out all the people who are not from the Europe, but I mean, it was not possible for Home Office to remove all the immigrants from all the other countries. So basically the soft target was the poor countries, South Asian countries like India, Pakistan, Sri Lanka, to reduce the number of immigrants. And what we have experienced so far, what we see is basically that this number was to control the books, basically to show the less number of immigrants in the books of the Home Office, that they were proudly saying that they have controlled the number of immigrants from this number to and reduced to this number in the next year. So maybe we are just the victim of controlling the number of immigrants in the country.
Yeah, thank you. Thank you very much for that. I'm going to ask another question, and it's probably going to, and it's one, if we have time, everyone can touch on if you feel you have an answer. And it's probably the last one, but who else do you think needs to be made aware of the issues that we've heard today? And I'll start with Catherine, if that's okay.
Yeah, thanks, Clive. I think what's been great today is that this is the first time that everybody's spoken together on the same platform. We've all working in our own kind of silos, either on immigration, data protection issues, or racial justice issues. So I think it's amazing that everybody's kind of starting to see the links and seeing that this is all part of a bigger picture. So more people within those areas of work, I think, really need to know about it. There aren't many outside, well, actually in any of the spheres, even in the immigration sphere, there aren't many people who know about these cases. And yet it tells a big story and links to so much of what else is happening and what's going to happen for the newly announced highly skilled visa. I think also a really big part is going to be those working in either the private sector or those working on entrepreneurship issues and policy in the UK. So so encouraging talent from around the world and making sure that those who've done nothing different to many people in the UK are not disproportionately punished, but also then ensuring that this issue is sorted out enough so that it doesn't happen in the future, and we can still be a Britain that stands on an international stage, which I understood was the point of Brexit. Yeah. So in many ways, I think by these policies coming out and what we're finding happening, we're actually really undermining even what people voted for Brexit. So I think it's everybody who relates to that and who wants to work on those issues, especially in the business sector, really needs to know about that. And we're just starting to do that. Not many people know. So any help, again, would be wonderful to share these points.
Thank you, Catherine. Some of us did warn about this, but there's obviously no point to saying that. It's futile. We are where we are now, and we have to deal with it. Does anyone else want to come in on that particular point about any other groups that need to know about this, or we can share that information with? No? Okay, well, I'm going to thank everyone for their contributions today. I know some of the contributors have left for other meetings. I wanted to thank them for their contribution. We'll be passing that on. If anyone has any other questions, and I know there are other questions, I'm sorry we couldn't take them all. Some of them have been answered on the Q&A, and I'm grateful for those panelists that did do that. Thank you very much for that. Thank everyone for their contributions today, especially Abiome and Salman, and we wish you the best of luck with your campaign. There are a lot of people rooting for you, campaigning and working to make sure that this injustice is turned around. Thank you for your bravery in speaking out today. It can't have been easy, and it's really important to hear your voices. And thank you for everyone else that's attended and spoken so well today, and all the work that you do in your individual and respective organisations. Next week, the APPG will be following up with you and sending some short briefings and parliamentary questions, but also send over the recording of this event and the Newsnight coverage. Now, for anyone present working more directly with the Home Office and Home Office civil servants who might be working on the highly skilled cases, we would be grateful for being able to be put in touch with them. And we're keen to understand what difficulties they have faced around investigations and the large number of court cases. And we hope we might be able to make this situation better for all. But we're also seeking time in Parliament to raise this issue. And I would be very grateful for any support in this endeavour. So please contact my office if you can help us with this. And finally, thanks once again to the Runnymede Trust and the Migrants' Rights Network for jointly hosting this session. Have a safe and pleasant journey home and a good rest of the day. Thank you very much, everyone. Take care. Bye-bye.